and then we'll begin. So I want to say good evening to everyone, and I'm happy to see you all. I know that many of you were here last week for the first class in this series, which was estate planning. That class was incredible. It was really well received. It was packed with valuable information, really information that few of us understand without guidance and targeted education. So I welcome back all of you who joined us before, and welcome every newcomer who are here for the first time tonight. And so if any of you don't know me, my name is Kimberly Connell, and I'm the Caregiver Services and Support Specialist with Onondaga County Office for Aging. And as I said last week, really information that few of us understand without guidance. Hang on. Okay. And as I said last week, whenever I talk with the caregivers that I support about education topics that they want us to do for eye care, financial concerns and helping paying for long-term care for their loved ones or even for themselves is always a top priority. And yet so many of us don't think about it or prepare for it until a crisis occurs. And so all of this knowledge suddenly becomes necessary and we don't have any of it. So I do recommend to almost every caregiver I speak with to begin planning early and to at least speak with an elder law attorney about the what ifs and what should I do's before a crisis occurs. And that's why we're really happy that you're all here tonight, because that tells us that you're beginning to be educated and make a plan. So tonight, on behalf of Onondaga County Office for Aging and Caregiver Services, I'm very pleased to welcome you all to our Institute for Caregivers second class in our series on the key financial and legal issues in caregiving, titled How to Pay for Long-Term Care, Understanding Your Options. And once again, this class will be presented by our wonderful elder law attorney, Tim Crisafulli, and we're thrilled to have Tim with us. He's a wonderful teacher and extremely knowledgeable. So let me just tell you a little bit about him. Tim devotes his legal practice to helping families. And by focusing his practice on trust, estates, probate, and elder law, he helps clients ensure their wishes will be honored for their life savings and have their life savings protected and their loved ones cared for. So whether you're planning ahead or facing a crisis, Tim's empathetic approach and strong listening skills leave clients informed, empowered, and relieved. That's a big one. Tim is a former social studies teacher and past president of the Fayetteville Manlius School Board, and education remains essential to Tim's practice. He invests the time necessary to ensure that clients truly understand the challenges that they face, explore their options, and then tailor an approach that fits their individual needs. Tim strives to ensure that clients have an understanding of their estate plans, and that it is as thorough and as complete as the plans themselves. So their knowledge and the plans are as complete as they can be. So Tim, we're thrilled to have you here. Welcome once again. I'm going to spotlight you for everyone. Okay, so take it away.
Okay, and let me just share my screen, make sure that's working. Is it?
Okay, hang on.
Is my screen being shared successfully?
You are. We see you fine. I see you fine.
You see me? Are you seeing my screen that says welcome?
Yes. Yes.
You are. Okay, super. All right, so thanks for the introduction. I'm grateful to Onondaga County Department of Adult and Long-Term Care Services for the Institute for Caregivers program. It is nice to be here with you tonight for part 2 of this 2-part series. So what I thought we would do tonight, as we're looking at this part 2 of how to pay for long-term care, is first of all a very quick review of part 1, which was all about estate planning and administration. I want to take a moment and identify what you came to learn. You're taking time out of your busy lives to be here, so let's make sure that whatever it is that drew you in based on title or anything else gets some attention. I plan to talk about what is long-term care. We'll look at what it takes to get medically qualified for long-term care. And then we'll talk about what it takes to become financially qualified. for long-term care, whether that happens in a skilled scenario or a different scenario, and I'll break down what that means. We'll talk about when that planning can occur, whether it's pre-planning if you have enough advance time and advanced warning, or if we're talking about crisis planning where there is little or no time to prepare. And then we'll look at community-based Medicaid services and how to financially qualify for that, because qualifying for Medicaid paid for services for those who are living in the community or an assisted living program facility is very different than the scenario where somebody's looking for Medicaid to pay for a skilled care facility or a nursing home level care. And then from there, we'll close. A quick word on me. If you were here last week, you might remember I like to introduce myself with logos. I am a Buccaneer forever in my heart, meaning I am from Oswego, New York. That is my hometown, and those are our mascots. Next up, I went to Lemoyne College out of high school for undergraduate, where I studied history. My dad said to me, "Hey, what are you going to do for work with a history degree?" So I also got a teaching certification, and I taught at Fayetteville Manlius Middle School, 7th grade social studies for 5 years, and then high school for another 5 years. Got a master's degree at SU while I was there, thinking I was going to teach forever because I loved it. But then I realized it might be just as much fun, married, mortgaged, baby on the way, to drive us all into debt and go back to Syracuse for law school. So I did that. After that, took a job at a firm in town, Hancock Estabrook, worked there for about 6 years. During that time, I picked up a post-law school degree at NYU School of Law in tax law. And I'm currently, in addition to running my own law firm, I'm currently a member of a national organization of elder law and estate planning attorneys called Lawyers with Purpose. And they're good enough to send me around the country a couple times a year to teach other attorneys how to do the very things that I'll be sharing with you today. Why I love my job, especially the parts of it that I'm talking about with you tonight, is because I get to deliver relief to people. People come in need of long-term care and they're scared. They're scared because they got a loved one who's facing a horrendous crisis medically, and they're also scared about what's going to happen financially. And I can't fix medically, but what I can generally do is put people in a way better position financially so that they know that they're not going to go broke, as is many people's worst fear when faced with that kind of diagnosis. So the part one recap of some things that we did last week. We looked at the key documents of estate planning, power of attorney and healthcare proxy. And boy, if you attended last week and you took anything away from it, I hope it's the idea that not all of them are created equal. I always get a little nervous twitch when somebody comes in and says, well, my loved one has dementia, but it's okay. I got power of attorney years ago. I get nervous because it is my hope that it's a good, high quality power of attorney document that will enable all things to be done that need to be done. Often it is, sometimes it's not. Point being, do a review of those documents if you haven't recently, or get them in place if they're not in place. We talked about the MOLST, that medical orders for life-sustaining treatment. We talked about what it's like to have a will and some things that can be accomplished if you do have a last will and testament. Took a good long time looking at how assets move when someone passes away, whether that's through the rules of probate, if there is a will, or intestacy, that set of rules as to who gets what that the great state of New York wrote for you if you don't have a will. And then we got into the idea that there are plenty of assets that don't care if you have a will or not or what it says. Those are the ones that move by operation of law, whether that's through joint titling, beneficiary designation, or something that might be in a lifetime trust. Just like and one last thing about last week's program, it was recorded, and if you would like to see it or get the link to it, contact Kimberly after this and she can send you that link so you can see it. Just like last week, I want to make sure that this week is all about what you want to know. So what do you want to learn? I know that you were invited to submit questions as you registered. One of them that came through is on the screen now. It's in what order do you roll in a Medicaid trust and apply for Medicaid? And what if the trust company does not follow through? So that's one thing I'll be sure to address tonight. Is there anything else that anybody else on the call would like to make sure that we get at some point during our conversation tonight? See something in the chat box? What is spousal refusal and how does it work? Got it. Thanks for that in the chat box. Anything else that anybody else wants to make sure we get at? Whether you hover around and click on chat, type it into the chat box, or just start waving around. I'll unmute you. I've got, is every state different as it relates to these rules? Good.
And related to that, Tim, is the person who mentioned in their registration that they wanted to be sure they understood New York State rules with regard to these issues.
Got it. And anything else that you want to make sure that we get at during the course of our conversation tonight? How to protect an individual with special needs trust so as not to jeopardize government benefits.
Oh, good one.
Got it. Okay. I'm not shutting off the questions. Anytime you come up with something, please do interrupt. Like I mentioned before, I used to teach 7th graders. I can take it, believe me. All right. So first thing I want to do is I want to get into this distinction of long-term care. What the heck is it with this term in particular? And so the first thing I want to do is I want to talk about what it is not. And long-term care is not healthcare. Healthcare is a phenomenon that is designed to get you better. So for example, if you fall and break your arm, healthcare is going to get you an x-ray, it's going to get you a cast, and it's going to get you rehab to put you back good as new. That's what healthcare is, and that's what healthcare does. Healthcare is paid for by health insurance, whether that health insurance is in the form of Medicare or whether it's private, like employer-based or some supplemental thing that you might have. That's healthcare. Long-term care is not healthcare, because long-term care is not designed to get you better. Rather, long-term care is an admission that you're just always going to need some level of support. It's intended to maintain you. That can happen in the home. It can be not all that intense. It can be just a little bit of extra help in the home, or it can be as intense as skilled care in a nursing home setting. Had another question come up there. I see it. What's the difference between a revocable and irrevocable trust? I'll make sure that I hit that one too. Thank you, Margaret. So as far as paying for long-term care goes, it's important to recognize that it is not paid for by health insurance. So Medicare is not going to pay for long-term care the way it pays for health care. And any private insurance that you have is not going to pay for long-term care the way it pays for health care. So a lot of what we talk about tonight is going to be, all right, fine. If long-term care is needed, though, how do you pay for it? And how do you do that without going broke, particularly if you've got some loved ones who are also going to have to live off of whatever remains. Before we get into paying for it, I want to talk just a little bit about the types of long-term care that are available. So the first level is adult care. This is the least invasive one. This is the one that's delivered in the home. Maybe somebody comes in for a couple hours a week. Second level, slightly more intense, is one that is delivered in assisted living facilities. So you're no longer living at home, but you're living in a place that does not have the intensity of nursing home care. And then finally, the third and most intense level of long-term care, that's skilled home. That's what people think of as a nursing home setting. So as far as figuring out which of those three levels anybody might qualify for, That's a medical determination. Lawyers don't make those. I can help people finance it, and I can help people preserve assets, but a lawyer does not make the medical determination as to what level of care somebody needs. It's a medical decision. The way it's done is that there's an analysis of these 1, 2, 3, 4, 5, 6 things known as activities of daily living. When I think of the activities of daily living, it's the stuff that you got to do when you first wake up. So if you take your routine all the way through, it's a question of, well, can you transfer by yourself from bed to chair or chair to bed? Can you walk yourself? Can you toilet yourself? Can you bathe yourself? Can you dress yourself? Can you eat yourself? Each of those is an activity of daily living. If an individual needs help with only one of those things, then that person is medically qualified for adult care, long-term care. If someone needs help with 2 of those things, then that person is medically qualified for the assisted living level of long-term care. And if someone needs help with 3 or more of those things, then that person is qualified for skilled care or chronic care. Now, I note that there's a way to get immediately qualified for chronic care or skilled care, even if you don't need help with 3 or more of those things. And it is a diagnosis of severe dementia. That alone will qualify someone medically for the highest level of care. So that's what long-term care is. That's the different levels of it. And that's how you determine which level somebody might qualify for. What we do now is we get into, all right, how are we going to pay for it? So the ways that long-term care is paid for, descending here, first up is Medicare. Now you might remember a few slides ago, I said don't count on Medicare to pay for long-term care, because it doesn't. That is true, but I have to make note of the fact that there's a very temporary Medicare benefit. Specifically, if somebody goes from at least 3 days of hospitalization into a rehabilitation scenario, whether that happens under the roof of a nursing home or not, if that person goes from 3 days of being admitted to a hospital straight into a rehabilitation scenario, then Medicare will pay for up to a maximum of 100 days. Now, it's not full coverage. It's full coverage for some of the time, and then it's only partial coverage for the last 20 days. But the trick is, as soon as the medical folks determine that rehabilitation isn't working anymore, there's no further progress being made, then you're done with rehab and you get reassigned to being a skilled care patient. Doesn't even mean you switch beds. It might all happen in the same room, but it's a sea change financially, because the moment someone is no longer in rehabilitation, that person gets no more Medicare payments for the care. So it's a maximum of 100 days or when rehabilitation status stops. Second potential source of payment for long-term care is the VA for those who qualify for some benefits. Next source is long-term care insurance. If you have it, that's great. If you don't, notice that it is different than health insurance. It says long-term care insurance. It's always worth investigating, but most people, most of my clients find that the best way to buy it now is to get in a time machine and to go back to about 1992, when they were all younger and healthier and when there were more cheaper policies available. So don't think it's not possible. By all means, investigate long-term care insurance, but it's very rare that I have a client who's in a position to buy it. Number 4 is the least possible desirable way to pay, and it's private pay. We talked a little bit last week, and we'll talk a lot more today about if you must private pay, you essentially spend down your assets until they're low enough, and then finally Medicaid will pay for your long-term care thereafter. And when I say spend down until low enough, I'm going to get really specific on the numbers with everybody on the call tonight. So that is who pays for it. So now I'm going to transition over into, well, what about you? What about each person on the call or anybody you're thinking of as we look at these big broad terms? Okay. Now, I'm always popping my eyes up at the chat room, and I'm not seeing anything in there. I'm not seeing any questions. I will remind you, interrupt the heck out of me the moment you have any questions. Type it in the chat box or otherwise flag me down. So when a client comes in and that client wants to know, well, what about me? What about my numbers? What about my assets? The way I run through this scenario with people is I say, well, if you or your spouse, if you're married, if long-term care is ever needed, that's a medical decision. But financially, what happens is that every single one of your assets, alone or as a married couple, they're going to either be over here on the left side of this document, or they're going to be over here on the right side of this document. And if those assets are over here on the left side, that's what's in jeopardy. If it's on the left side, it's considered available to pay for your long-term care, and therefore you must. So if you've got an asset on the left side, you must pay for your own care, and it's expensive. In this part of the state, we're about $13,000 to $16,000 a month for skilled care. And if your asset is on the left side, you got to spend down at that rate until your assets are low enough. And then once they're low enough, I'll get specific in a minute, then Medicaid will pay for your future long-term care. That's for the things that are over here on the available to pay side. By contrast, if you've got an asset over here on the right side, it's not available to pay for that care. And you can quite literally, get this, you can quite literally have millions of dollars over on the right side, not available to pay for the care, and still qualify for Medicaid program to pay for your cost of long-term care. So much comes down to, well, what are your assets? And are they over on the left side where they're vulnerable, or are they on the right side where they're safe? And that really is a case-by-case analysis. It's a state-by-state analysis too. Somebody asked the question, are these rules the same across all states? No, absolutely not. What is the same across all states is the Medicaid program itself. And it provides kind of an umbrella of rules. But each different state is free to tweak those rules as that individual state wishes. A big example is qualified assets, by which I mean things like IRAs and 401ks and 403bs. In some states, like New York, the underlying amount in an IRA or a 401k, that's over on the not available to pay for care side. That's great news. There are tricks to that. It's not instantly exempt. You got to put it in this thing called payout status. There's details to it. But long story short, there's a way to make something like an IRA instantly be over on that right side and be safe. Some states don't treat it that way. So it really is state specific. So let's focus for a moment, realizing that there are some assets that are over on that right side and a way to get assets over onto that right side. But let's just take a moment and look at, well, what happens to the assets that are on the left side? If it is available to pay for care, I've said a few times, you got to spend it down until it's low enough. So let's look at what low enough means. So these numbers are based on chronic Medicaid. That's the nursing home level or the skilled level. Now, later on in this program, I'm going to talk about community-based Medicaid, which is long-term care services provided in the home or in an assisted living program facility. That's coming later. These numbers that we're going to look at for the next few minutes and the concepts that we're going to look at for the next few minutes, This is for that more intense level of care, nursing home, skilled care, chronic Medicaid. Okay. All right, I've been talking. I'm peeking at that chat box, see if anybody's got anything. I know I got to pause sometimes here, get all excited about this stuff. Good? I don't see anybody waving around either. Okay. I don't see anybody sleeping either. So all good signs, all good signs. All right, so the fear that people have when they come to me initially is they've heard, oh, they're going to take all your assets. You're sick or your spouse is sick, somebody's going to a nursing home. Well, they're not taking all the assets, but they're taking a lot of what's over on that left side that's vulnerable. I've got this broken down to show the assets that the applicant spouse may keep and the assets that the community spouse may keep. Here's what that means. The applicant spouse is the one that must apply for Medicaid, the sick one, the one in the nursing home. The community spouse, if there is one, is the one who's healthy enough to live out in the community. As far as the numbers go, the resources, think life savings, that are over on the available to pay care side. The one who's sick can keep up to $16,800. If there is a healthy community spouse, that one can keep a range, but it's never more than $137,400. Good question in the chat box. What about a single individual with income and assets to spend down? All right, to think about a single individual, take all this community spouse information and ignore it. If there is no healthy spouse, then the only amount with no planning that a single individual in a nursing home can keep is that $16,800 amount, which is on the left side that's vulnerable. Same thing happens, right? If both spouses end up needing skilled care, then you have two applicant spouses. So that's 16.8 plus 16.8 only. Okay. So that's resources. Think of life savings that is over here on the left side. Those are those numbers. There's another number below there, which is income. And I like to encourage people to think about income as mailbox money. Whatever shows up in the mailbox every month from all sources, whether that is Social Security, maybe a pension, maybe required minimum distributions from an IRA or a 401k. Whatever the monthly stream of money is, the one who applies for the Medicaid benefit may keep $50 a month. And if there is a healthy spouse who's a community spouse, that one may keep $3,435 a month. If the healthy community spouse has more than this, then the healthy community spouse has to pay over 25% of the excess beyond $3,435. The point of all of this on these two slides is, if you got assets on the left side available to pay, you got to pay until you get down to these numbers. If you happen to have a healthy community spouse, that person gets to keep more. But if you don't have a healthy community spouse, because that one also needs long-term care, or because that one dies, or because it's just plain an unmarried individual, then you only got the $16,800 to play with. We good? Okay. So inevitably, here's what people do. They're in the hospital. They hear, you're not going home. You got to go to skilled care. And if it's an individual, you only get to keep $16,800 and everything else is going away. When that happens, everybody gets really, really generous. It's like that Oprah Winfrey Christmas special used to be years ago. You know, you get a car and you get a car and everybody's getting all these gifts because, hey, if it's got to go anyway, people think, well, I'll just get it out of my name. I'll just get myself down to $16,800. Problem is, that doesn't work in this nursing home, skilled care, chronic Medicaid scenario because of this phenomena called the look back period. Okay. A lot of people, by the time they've come in to see me, they've done some research and they've heard of this 5-year rule or this look back period thing. That's what we're talking about here. Okay. So the way this works is people are tempted to just say, I want to take everything that's on this available to pay care side and throw it over to this not available to pay care side, or just gift it away. But again, they got to be aware of this look back period. So the way it works is, imagine this green arrow. That's maybe when dad is sitting in the hospital bed and he's just been told, you're not going home, sir. You got to go to a nursing home. So he gives everything away that day in that hospital bed. And then the blue arrow is the day he shows up in the nursing home. Picture a timeline going from left to right here. The blue arrow is the day he shows up in the nursing home and he says, hey, I only have $16,800 to my name on the left side. I'm good. I'm qualified for Medicaid. Okay. But the question comes up in the Medicaid application during the 5 years prior. And the 5 years prior is represented by this blue bar that says look back period. During this 5 years prior, did you give away anything? And the answer is yes. I gave away a bunch of money on the green arrow day. Oh, well, because you did that, even though you would have been eligible for Medicaid to pay for your nursing home beginning right here on the blue arrow, you're not going to get any benefit. Instead, what's going to happen is for a series of months, you're going to have to pay all by yourself. And where's that money coming from? Well, you got to go and get it back. Whatever it is that you gave away, go get it back, or the state can go sue the people to whom you gave it in a worst case scenario. So this is how the look back period defeats that last minute giveaway. See a question roll in. Can monthly income in excess of the $50 a month be accumulated up to the max of $16,800? No, it can't. Anything in excess of $50 a month of income, it just goes away, period. Now, if you keep that 50 each month, yeah, you can keep the 50 and let it build up to the 16,800, but you cannot keep that excess of 16,800. I got a question about pooled income trusts. I'm coming back to it, and I'm coming back to it when you talk about community Medicaid. So save that for just a moment. So let's take this visual
Hey, Tim,
and give
I'm
it some
sorry.
numbers.
I have a quick, I wasn't quite sure how that question was answered. So if you are getting an income of $50 a month, you can just sort of put that in the bank and let it build up to $16,800. Is that what you're allowed to do if you don't spend it? Okay. And then you can, with that $16,800, if you ever get there, if you live long enough, that would be a long time.
That's a long time.
Then you would just be able to gift that if you wished, or would that have to be used for your healthcare expenses?
Right. So that account of $16,800, it could go to a beneficiary as long as it doesn't pass through your estate. So if you get it to move by operation of law, by jointly titling it, or by having a designated beneficiary on it, that's all from last week, then it can go, the 16,800 could go to someone of your choosing.
Oh, okay.
But if it's in an individually owned account that passes through your estate, then the state of New York is going to reach in and take it.
Okay.
That, by the way, is another distinction among states across the country. Some are more aggressive than New York about reaching in and getting reimbursed.
Thank you.
You bet. I'm just jotting down a few things on that are coming up in the chat. But looks good. And I saw explain how to protect IRAs. You got it. All right, so here's that example, and I hinted at it a little bit. Let's say dad left the hospital and he went into rehab 20 days ago. So as a rehabilitation patient, he's on that Medicare benefit. He starts in rehabilitation, but you get the notice all of a sudden that dad's not progressing in rehab anymore, and he's going to be reclassified as a skilled care patient in 2 days. It's about all the notice anybody gets. Dad feels generous. He gives away $200,000 immediately, realizing he's got to get down to $16,800. And he's got no available resources as of the first day he's classified as a skilled care patient. But what happens with this look back period? Well, question one is, hey, Dad, did you make any gifts during the last 5 years? Well, the answer is yes. Okay, so the way you calculate it is you take the amount of the gift, we said $200,000, divide by this number called the regional divisor. It's a made-up number that the state of New York makes up every year. I'm pretending it's $10,000. It's currently 11 and change, but me and math, 10,000 it is to make my life easy. And what that means is that red box, okay, Dad, because you made that gift, you would have been eligible right away for Medicaid to pay for your care, but sorry, you're going to have to privately pay for a 20-month penalty period. So what can people do about it? Another way to say that is, how can you get your stuff that's over on their left side and vulnerable over on to the right side where it's safe? And the answer is, give it away. Give it away at least 5 years before you seek long-term care. And if you want to know what that date is, you take off your shoe and sock, you look on the bottom of your foot and you see what the stamp is that tells you exactly when you're going to need long-term care. And then you give away your stuff at least 5 years before that. Because you've given it away at least 5 years ago, it's not on that left side vulnerable anymore. It's gone, not part of your life, you're safe. Now, when I say give it away, I want to just take a really quick moment and point out there are a couple different ways to give away your stuff. You can just make an outright gift. Here you go, son. Let me watch the smile on your face. Here you go, kids. I'm going to give you the deed to my house, and I'm going to keep life use of it. That's one that a lot of people have heard of. Outright gifts, as a practicing attorney, scare the hell out of me. It's because I always see them go wrong. I see things like, I gave you, son, that $40,000 years ago to hold on to. What if I don't make it the full 5 years before I need long-term care? I'm just giving you that money to hold. And then the son spent it, because money has a way of going away. Or maybe the son got in a car accident and got sued and can't keep the $40,000 anymore that I gifted him for safekeeping. Or maybe he got divorced, or maybe his business failed, or maybe he died. In any case, an outright gift is scary because you can't get it back. And you can't get it back, especially if you need long-term care in fewer than 5 years. With the house, giving away the deed to the house and keeping life use, well, it does get it out of the left side where it's vulnerable there. But boy, you're locked in, because now your kids really, truly own your house. Sure, you have the right to live in it, but what if you want to sell it and upsize or downsize? You can't without their permission. And what if they've got divorces or lawsuits, or they die, or they've got complications? Another thing is, if you sell a house where you have life use, well, now you've got cash from it. And that cash is vulnerable to long-term care. So I find people are very restricted when they do just good old outright gifts in the hope of some cheap and easy Medicaid planning, because there's too many opportunities for it to backfire or cause problems. Typically, I'll suggest to people to instead use an irrevocable trust. I am not going to say too terribly much about an irrevocable trust in this particular format, but I am going to make sure you know where you can learn a lot more. But in the end, the thing to know for this slide is that an irrevocable trust is a place where you may put assets you want to protect. You may keep control over those. You may change what's going to happen to them after you die anytime you want to. And if you ever need to get them back, there's a way to get them back. Like if you don't make it the full 5 years, or if you just decide to heck with the kids, I'm taking big vacations. There's always a way to get it back. Now be careful as you Google and as you talk to people, not all irrevocable trusts are created the same. See a lot of weird stuff out there. So I'm talking about a very specific kind. I also want to take a moment and yeah, go ahead.
Amy had a question. I think that I wanted to address before going on to the trust. And she says, can putting assets towards home repairs and related items be considered asset transfers? So that would be, yeah. That would be, Amy, I'm thinking you're thinking of home repairs in the home of the person who's seeking to protect their assets or provide. Oh, okay, yes.
Yeah, I think I got it, Kimberly, and I've got a slide that's going to address that very thing. So I've captured it. I'm going to pause it, but I'm going to get there.
Okay.
All right. Next up, a revocable trust. I just want to touch on this because these are heartbreaking conversations that I've got to have with a family about once a month, and it hurts me whenever it comes up. But I want people to know about it. So a revocable trust sounds less scary, right? Sounds like you can always change it. You can. With a revocable trust, you keep total control over your assets. Those assets are protected from probate. Think back to last week. But sadly, the assets in a revocable trust are not protected from Medicaid. They're not protected from nursing home costs. They're not protected from lawsuits. The only thing a revocable trust does for people is it avoids probate. That's it. So the heartbreaking conversation that I have usually with a family about once a month is the adult children or maybe the healthy spouse will come in. Somebody's in need of skilled care. Say, don't worry. That person going into skilled care put everything into a trust more than 5 years ago. Say, oh, great. Let me see the trust. And they take it out. And sure enough, the first word is revocable. And I know immediately I'm about to have a real tough conversation with them because they always look at me and they say, but we did this to protect the assets. I say, I know. And you did protect them from probate, but a revocable trust does not protect them from the thing you face right now. So I just wanted to make that quick comparison. If you're going to give stuff away, you have a couple options, outright gift versus irrevocable trust. I almost always prefer that clients use an irrevocable trust because they keep a lot more control and a lot more flexibility. And I caution folks that if you are looking for asset protection, a revocable trust is not going to get you there. There is a whole heck of a lot more information about this slide. I've got a 70-minute workshop that really elaborates on this and a few of the things from last week. If you want to look at it, it's called my Estate Planning Essentials Workshop. There's my website address. And just to show you exactly how you would navigate to it if you want to see it, this is the website. If you come down to workshops, here it is right here, Estate Planning Essentials. You just click on the watch now, and you're going to see a description of the differences between irrevocable and revocable and how those can help. I've always got a lot of educational materials on here. Feel free to explore them, but it's that one in particular, Estate Planning Essentials. Watch it anytime. It's on demand. That can elaborate on the things that you're seeing on this slide. I want to be careful to save the time to move on to the other promised things and make sure we get at those questions. So up till now, remember where we are and where we're going. We've talked about, all right, what is long-term care? What if you need that skilled level? Uh-oh, they're going to take all your stuff if you leave it over on the vulnerable side. What can you do to move it over to the safe side? Give it away at least 5 years in advance. And I prefer irrevocable trusts for that. Well, that's great if you got a time machine. But what if you don't have 5 years in advance? The planning just didn't happen because that's the way life is for just about everybody. So if you are in a crisis, and if long-term care is needed right now, what do you do about it when it's too late to do that pre-planning and to wait for this 5-year look-back period to expire? But you don't feel like paying $13,000 a month until assets are down to those low numbers that we looked at before. The good news is there are options. Now, the times when I see clients and families get into this situation, it usually happens when there's a medical emergency, broken hip, pneumonia, whatever it may be, and the discharge plan ends up saying this person can't go home and live independently. This person's got to have long-term care, maybe skilled. I get calls when someone's getting reclassified from rehab into being a skilled care patient. You know, the family leaves the hospital, oh, everything's fine, Medicare is paying for the rehab, and it is, but all of a sudden rehab stops because the loved one is no longer progressing, and now all of a sudden they're on that path of paying $13,000 to $16,000 a month. Sometimes people come in when there's a rapidly developing health issue. Often it's dementia, Alzheimer's, something that is Parkinson's diagnosis, the kind of thing that doctors are saying, look, make plans because this could develop quickly. Sometimes it's an overwhelmed caregiver. I see this one all the time and my heart just breaks for these folks. They're going to take care of their loved one in the house by themselves, period. And they do. And they do it for longer than anyone could have imagined until the caregiver breaks. That's hard. But that can be a triggering moment when the person in need of care needs it outside the home. Sometimes it's when the caregiver spouse dies or a caregiver child moves away. So when these things happen, when it is time for skilled care and you don't have 5 full months to plan, I think of it as triage. There's an order in which I take clients through ways to save their assets. So beginning the triage, we look at, well, what's not available? Specifically, what are the things that are over on that right side of that visual I keep coming back to of assets that are not available to pay? Is the money in the form of IRAs? Great. What are the tweaks we have to make to protect those? Somebody asked earlier, how do you plan with IRAs? The answer is it's important to have perfect designated beneficiaries in place. I talk about that on the Estate Planning Essentials workshop. The other thing that matters is if someone has an IRA and is seeking Medicaid to pay for long-term care, they have to put it in what's called payout status. So essentially, you have to take required minimum distributions, regardless of your age, even if you're under 72 and a half. But you have to do it on a Medicaid table. You don't do it under the IRS tax tables. So there are ways that you could protect a lot of IRAs. They're very good, very protectable assets in New York State, but there's a nuance to it. Yeah, so beneficiary designations matter, and knowing that you can put them in that payout status to protect them. Other things that are not available, and this goes to a question in the chat room, what physical assets can you keep? Well, some things are exempt. The tangible stuff in your house, salt shakers, tables, chairs. Now, if there's a Picasso hanging on the wall, that's a different topic. But if we're talking day-to-day household items in common use, that's not available to pay. That's already safe. The house is interesting. It's in the chat box. So houses are so confusing because you will hear people say the correct first half of the sentence, which is, don't worry, nobody can take your house if you or your spouse ever need a nursing home. True. And the rest of the sentence is, until after you're dead. Because what happens is the state will not take your house for as long as you or your spouse can live in it. But if upon the death of the second one, that second one had consumed Medicaid services, then the state spent time keeping track of how much money it spent on that person's behalf. And then when that person dies, the state will collect on the lien that it put on that person's house, compel the house to be sold, and then get reimbursed.
But not if the community spouse is still living in it, correct, Tim?
Not if the community spouse is still living in it, and the community spouse then never needs long-term care.
Right, okay.
Next level of triage beyond what's not available is permissible spend down. I'll look and I'll say, all right, how much money do you have over what you could keep? And is there any place that we can put that money, even here in this crisis moment when we don't have 5 years to plan with? Is there any place where we could put that money that's going to benefit the person needing the Medicaid and be okay and not trigger a penalty period? These are things like prepayment of burial expenses, not just for the person, but for the person's spouse and kids. Home repairs, that's a big one. If ever there were a time for a new roof or a new furnace, this might be it. New windows. A new car. This one sounds odd because people say, well, that person's never driving again. Doesn't necessarily matter, because if the car is being used for that person's benefit, it's okay. So one of the things I'll do with clients is come with a permissible spend down plan. Some things are okay to spend money on, some things aren't. We come up with a plan that fits that particular person, that particular family. Next step of triage is exempt transfers. There are some things that you can give to certain people as a gift, and it does not trigger a penalty period, and it doesn't matter if you do it within the last 5 years. For example, you can give anything you want to your spouse. Now, remember though, the healthy spouse can only keep just so much. There's a limit on what the healthy spouse can keep, but the transfer to a spouse is perfectly fine. It's unlimited. You can transfer a house to an adult child who has lived with you for more than a year in the house. And because that adult child lived with you long enough, you were able to stay out of needing long-term care longer than would have otherwise been the case. Transfer a house to an adult child who has a disability as defined by the Social Security Administration. There are certain transfers that you're allowed to make even at the last minute. So as we triage, that's the next step. What's not available? What could we spend money on? Is there any exempt transfer that might make sense for this family? I was asked about spousal refusal. I use this one all the time. Another good example of how it's different in different states. New York allows it, most states don't. But the idea of spousal refusal is this came from the recognition that the law was putting married couples in a horrible situation just because they were married. You got a healthy spouse and a sick spouse. Why should that healthy spouse have to worry about complete impoverishment just because of the misfortune of having a husband or a wife needing a nursing home? So what people would do in that situation is they'd get divorced and they'd separate their assets legally so that at least the healthy one could keep something. That's bad policy. That's the law doing a bad thing to people. So this other strategy evolved called spousal refusal. This one blows everyone's mind when they first hear it. It works only if you've got a healthy community spouse But basically what you do is step one, you transfer everything from the sick spouse to the healthy one. Make sure the house is in the healthy one's name alone. Make sure all the bank accounts are in the healthy one's name alone. You transfer everything to the healthy spouse. Remember, that's an exempt transfer, transfers among spouses. And then when the sick one turns in the Medicaid application, the healthy spouse also submits a document that basically says, I'm the healthy spouse. My husband or wife is applying for Medicaid. I know that I'm legally obligated to contribute, and I refuse to do so. And that's it. And when the healthy spouse does spousal refusal, the healthy spouse's assets are disregarded, and the sick spouse qualifies for Medicaid, period. It's magical. But then there comes the risk. So the risk is, if the county chooses to, the county can pursue that healthy refusing spouse and say, all right, healthy spouse, we approved the sick one. Sick one's getting the Medicaid, but we're suing you and forcing you to pay your share. It's a risk. Now, some counties pursue and some counties don't. In the counties that do, I've asked Medicaid attorneys, I said, when do you choose whether to pursue the healthy spouse or not? And they say things like, well, you know, if it's a large amount. So well, how much is large? Well, I can't get a straight answer. I've tried a lot of times. It's just not out there. There's no bright line. But what I will say is that even if the healthy spouse does get pursued, they're still better off. Because instead of the healthy spouse being compelled to pay at the private pay rate for a nursing home, which is about $13,000 to $16,000 a month, even if the healthy spouse is compelled to pay, they're only paying at the lower Medicaid reimbursement rate, which can be almost half of the private pay rate. So instead of being compelled to pay at $16,000 a month, maybe they're still compelled to pay, but only costs $8,000 a month. Still awful, but better. So spousal refusal, that's how it works. And it's a tool that is often used where there's a healthy spouse. Next in triage is promissory note planning. And I'll use this where I don't have a healthy spouse and I can't use spousal refusal. And basically, promissory note planning is where you take, big oversimplification here, but you take about half the assets of the sick person and you give them away. I like to use an irrevocable trust, but you give them away at the last second. That triggers that penalty period. For a number of months, that person's got to privately pay somehow. And the way that person privately pays is you take the other half of the money and you turn it into a stream of monthly payments so that it gets that person through the penalty period. When the dust all settles, the family is able to keep about half of all that would have otherwise been lost. I zipped through this slide fast. Each and every one of these 5 possibilities, they are loaded, they are complex, they have rules and exceptions to the rules and exceptions to the exceptions. It gets crazy and it gets crazy fast. When I say half, the calculations are mind-blowing. But the point is, and the big takeaway from this slide is, even if you didn't have 5 years to plan, and even if you find yourself with a loved one who needs long-term care, even skilled level, there's still a lot you can do to preserve a lot of assets. Last concept I want to get into before I go back and make sure that we've hit all the questions is I want to get at this concept of community-based Medicaid. Remember, I laid it out earlier. I said, we'll come back to it. Now we're coming back to it. But for a while here, last 5 or 10 slides, they've all been about chronic care Medicaid or nursing home level care, skilled care, right? That's the one where we've had this 5-year look back. That's the one that we've been on for a while. That's the one where I would use this triage. But now what I want to do for the last concept is I want to talk just a little bit about community-based Medicaid, which you might recall from early on. This is care that's provided, and it's still long-term care, still an acknowledgement that somebody's always going to need some level of help, but it's provided in a less intense environment than a nursing home, whether that's at home or in an assisted living program facility. For example, some ways that long-term care is delivered at that lesser community Medicaid level is an assisted living program, maybe an assisted living program with memory care. Now be careful here, because not every assisted living facility accepts Medicaid. Some do, some don't. You got to ask it on the way in. But if you have an assisted living program or an assisted living program with memory care that does accept Medicaid, then the type of Medicaid it will accept is community-based. You don't need that chronic care one that we've been talking about. It's more generous. You'll see you can keep more assets. I'll get there in a second. Another way that community-based Medicaid is delivered is with the PACE program, or that program of all-inclusive care for the elderly. This is where somebody is still living at home, but they get picked up several times a week and driven to the place where all-inclusive care is provided. Medical care, socialization, all the stuff they need. Another way that community Medicaid is delivered is in-home. Maybe someone paid for by the community Medicaid program comes into the house and provides care for 2 to 10 to 30 to all of the hours in a week, depending on the medical diagnosis and what the person needs. And then finally, a lot of people have heard radio ads for this thing, Community Directed Personal Assistance Program, CDPAP. That's the one where you, who need the community-based Medicaid benefit, can pick whoever you want to hire. Pick a son, pick a daughter, niece, nephew, neighbor, friend. You get qualified financially for community Medicaid, and then that person who you chose to deliver your care gets paid for by the Medicaid program. So it's a really nice thing that's out there where you can pick the person you want and get them paid through the Medicaid program. So often people will come in after they've voluntarily been providing the care for mom, dad, or a loved one. And I tell them about this, and they say to me, you mean I could have gotten paid all along for what I've been doing anyway? I say, yeah. They say, well, can we go back in time and do it retroactively? And I say, no, but we can do it going forward. So anyway, all these things are community Medicaid. Now, the reason I'm excited about community Medicaid these days, because you remember all the fuss about that 5-year look back period and how if you needed chronic Medicaid for skilled care in a nursing home, you better have given it away at least 5 years ago. But if you are in crisis, you got some things you can do, but you probably can't save it all. Better than nothing, but can't save it all. With community Medicaid, the old law was there's no look back period. So under the old law, what you could do is I could take a client and have them transfer all their assets out of their name today, November 9th, 2022. And under the old law, that person could be eligible for community Medicaid benefits as soon as December 1st, 2022. No look back period, no penalty period. It was awesome because people could get all these benefits on the screen, having given away all their assets days before seeking the community Medicaid benefit. No big surprise. The state legislature caught on to this and they said, no, we don't like that. We're going to draft a new law and it's going to say that there's going to be a 30-month look back period. So this whole strategy of no look back period, hurry up and give it away to get qualified for community-based Medicaid, the new law takes that away. Then came COVID. And because of COVID and various federal and state laws, long story short, that implementation of the 30-month look back period for community-based Medicaid, it's not yet implemented. And currently the can has been kicked about every 3 months for years. Now it's delayed until at least March 31st of 2024. So I point this out to families every chance I get, because if you've got somebody who may at some point need community-based Medicaid, you can still do it under the old law where there is no look back period, and you can get people eligible quite quickly. It's a window of opportunity. The law changed with respect to community Medicaid and the look back periods. And so I tell families contemplating community Medicaid, act now before that new law is implemented. Okay, that's it for all the new concepts. I got about 14 or 13 minutes to go. I want to sum up what I had prepared. I want to get to your questions and make sure I address them all. Okay. So things to consider. You took time out of your busy lives. You participated in this thing. What should you do other than sit there and feel overwhelmed? A very firm, good idea. Everybody should do this. Make sure your documents are up to date. They are not all created equally, as I made a big point of last week. Just because you have power of attorney doesn't mean you got the right power of attorney. Doesn't mean you got a high quality one. Get it reviewed. Make sure you got all that you should in place. Healthcare proxy too. Wills, all of it. And don't forget that your will doesn't control all your assets. So what about all those assets that pass by operation of law, whether that's beneficiary designation or joint titling? Are those up to date? If you got assets that you're looking to preserve, explore those pre-planning options. Well, maybe you won't need long-term care for 5 or more years. What are your options? What would an irrevocable trust look like? Maybe go on my website and look at that video where I talk about those pre-planning options in a lot of detail. Next, explore skilled care options. It's never too late. Even if there is a crisis, my heart just goes out to people when they come in and they tell me stories of how they're doing their own plan, but mom or dad needed a nursing home years ago. And I say, how'd you pay for it? He said, oh, we just wrote the checks until the money was gone. And I think, oh, that hurts, because a lot can be done even in a crisis. And then finally, explore those community care options. You got until March 1st of 2024, which is a nice long reprieve, but there's this window of opportunity where there is no look back period. So looking at questions that popped up either originally or that popped up in the chat room as we went. In what order do you enroll in Medicaid trust and apply for Medicaid? In that order. If you're using a trust, you want to get it in place, get it fully funded, which means move the stuff into it, then apply for Medicaid. And Medicaid applications are always effective on the first calendar day of a month. What if the trust company does not follow through? Well, that's rough. When you say trust company, I guess I'm a little confused about what that might mean. In New York, trust can only be drafted by attorneys. Otherwise, it's the unauthorized practice of law. And then some attorneys are very conscientious about making sure that all the funding happens, get all the stuff into the trust that needs to be in there. A rough thing is when somebody put forth the money and effort to have a trust, to make sure it was the right kind. Medicaid trust is a flavor of irrevocable, but then they never put the things in there. That makes my heart break, because the trust doesn't work if it's not funded. We talked about spousal refusal in good detail. We talked about how states are different. And what are the New York rules is too broad a question to possibly answer. Everything that I talked about tonight was the New York rule, but there are more, many more. How do you not jeopardize government benefits? Okay. So for this, Medicaid is a government benefit. And so we talked about if you want to protect your government benefit during your lifetime, perhaps you put your stuff that's otherwise vulnerable into your own correct kind of irrevocable trust. But this question also makes me think about, well, what about other people? What if my kids might need government benefits? What if my surviving spouse might need a nursing home after I'm gone? What if I got a child with special needs or a grandchild with special needs? Well, in that case, what you can do in your estate planning documents is every time you could leave assets to somebody directly in hand, don't do it. Instead of leaving assets to someone directly in hand, you wrap it in a protected trust. It's called a supplemental needs trust or a special needs trust. I know it's confusing because I'm rattling off this word trust constantly. And you got to be thinking, well, wait, is he talking the irrevocable trust one, revocable trust one, special needs, supplemental needs? Yeah, it's confusing as heck. There's so many different kinds and they do different things and they're not all created the same. Point being, if you leave somebody an asset directly in hand, that person might become disqualified from receiving government benefits. But if instead you plan in a way that you leave assets to that person in the right kind of trust, then that person can receive the inheritance, not get disqualified from government benefits, and also be able to use the assets that you left in the trust. Again, estate planning essentials. Look at the workshop, talks about those a lot. Revocable versus irrevocable. I touched upon one key difference of them, which is they both avoid probate, but a revocable trust only avoids probate. It does not protect assets from long-term care costs or lawsuits. Pooled income trusts. We didn't touch upon it at all. So the way these things are used is they are only available in that community Medicaid benefit scenario. They got nothing to do with nursing homes. They don't work in nursing homes. But if someone is receiving community-based Medicaid, that's anything on here, there is a risk that that person gets too high an income. Anything over $924 a month is too high an income. To bring the income down to that number and still qualify for community Medicaid, that excess above $924 a month, it's got to go somewhere. And the default is it goes to the Medicaid program and it's gone for good. But what you can do instead is get qualified for community Medicaid by taking that excess income beyond $924 a month and you put it into this thing, this place called a pooled income trust. Here I go with that trust word again. Here it comes meaning a whole different thing again. But a pooled income trust is an account. It's run by some charitable organization where your excess goes in there and then you're allowed to use it for your needs, your heat, your food, your fuel, your transportation. So that way you can still benefit from it and qualify for community Medicaid at the same time. It's a really good thing. The only downside to it is whatever's left in that pooled income trust upon your eventual passing, it goes away, stays with that charity. But hey, to fulfill a charitable mission, not necessarily a bad thing. Talked a little about how to protect an IRA. There's a lot more to that, and I do again advise you to take a look at that Estate Planning Essentials workshop. It'll talk about it more. But it all comes down to beneficiary designations. And like with someone who has any sort of special needs, maybe instead of leaving that IRA to someone in hand, you leave it to them in the right kind of trust. Careful, some kind of trusts destroy an otherwise really good tax benefit of tax deferred growth. There is a way to get it just right. And if you do, you get to this wonderful sweet spot of leaving an IRA to somebody in a way where it's protected, from their divorce, their creditors, their costs of long-term care, their issues in life. And even though you're enjoying that protection, you still get tax deferred growth, just like you would have if you left it to them outright for up to 10 years. And a spend down, that was a question that came in. Yeah, home repairs are often a way to organize spend down, but really I think the thing to do is to come up with a spend down plan. If we're ever in that triage, doing home repairs is definitely a thing to think about with spend down, but it's a very individualized family by family analysis and then decision and then plan. So with these 4 minutes left, those are the questions that came up along the way. I think I hit most of the things on the chat room, but let me just look at it real quickly. Can you put a federal government pension directly in an irrevocable trust? No, but you can take the monthly income stream and put that monthly income stream into the trust. Is it true an asset could not be held against you if it's paying out? Tough question for the minute I have. So I got to say, sometimes there's this thing called an asset to income rule, where if you own an asset, an income producing property, you can keep it. Sometimes tricky. If you're talking more about an IRA, yes, you can keep it if it's in payout status, which means something different than just required minimum distributions. So I got to say, sometimes, awful answer to give you, but hey, we got some constraints on a Zoom call with 3 minutes left. Did you get a copy of the PowerPoint? Yes, by contacting Kimberly. Is a Roth IRA protected from Medicaid taking it? No. Traditional IRAs are on that safe side. Roth IRAs are on the vulnerable side. On community-based Medicaid, was there an exception to going into a nursing home? Yeah, community-based Medicaid is the exception, and it comes in all those different offerings that I had up on that slide a moment ago. We talked about assets you could keep. We talked about home repairs. We talked about the excess of $50 a month. We talked about if there is no healthy spouse to plan with, and IRAs and trusts and special needs and the differences among states and spousal refusal, which brought me back to hello, everyone. So what's next from all this? What do you do? Well, what I would say is, if you have any questions after this presentation, ask me. I'm happy to answer anything that you have. If you go back on my website and you look at contact us, click in there, you got a box to write your message. Any questions you have, just send them on in. I'll get them and I'll respond. Other things to consider after this, there's the website if you want any of the other educational materials or if you have questions for me. And thank you, this minute and a half in front of the deadline. I made it. We finished on time. You were wonderful. And what I really appreciate about the night was you were so interactive. Zoom can be a really hard way to bounce questions back and forth. And it's still not quite the same as being in a room together. But hey, not bad, because you made it not bad and you were nice and interactive. So thanks for that.
I agree. I'm so happy when people actually are not intimidated on Zoom to go ahead and ask questions. So thank you so much for everyone involved. And hopefully in 2023, we'll do this and we'll do an in-person class, Tim. We can think about what the most pertinent sort of information that people want to have and be able to meet in person. But holy cow, thank you so much. I learned an awful lot once again. I think the IRA thing was like mind-blowing. I had no idea you could protect that from assets. So I'm not going to be back in the office until next Monday because I have community work. And so on Monday, I will have edited this recording by then, and I'll send out a link to both recordings from last week and this week, and also the presentation from this week as well. And of course, on the presentation is a link to Tim's website, Crisafulli and Gorman's website, but I can include that in the email as well. So any questions? You know, Tim is really open. He's wonderful. I just can't thank you enough, Tim.
Oh, I have so much fun doing this.
I
And you're all so
know.
much better behaved than my 7th graders used to be.
Yeah, I can tell. I mean, it's so wonderful to have someone presenting who has, you know, not only the heart of a teacher, but the education of a teacher and knows how to, you know, go through that. So thank you all so much for attending. Mary Beth says, thank you. It was thorough, intense, compact, yet very useful.
Thanks, Mary Ann.
Mary Ann's such a good writer. Okay, so thank you all so very much. And Tim, I'll be in touch. Hopefully you won't be undulated with too many phone calls. I think next week too, I'm going to remind everybody we're doing a program on the PACE. So if you're interested in learning about the program for all-inclusive care for the elderly, please tune in. I'll send a link to that in the follow-up email as well. So good night, everyone. Thank you so very much. Good night.